Good morning, everybody. Good morning, TikTok. So, this is a petition, this motion for leave to proceed in formal pauper. This is my affidavit of being broke. This is an affidavit for being broke. I'll go through some of these, all right? Declaration under penalty of perjury with the notary. Case number has not been assigned yet. Appendix A, B, and C is United States Court of Appeals, appears at Appendix A. The opinion of the United States District Court appears at B. For cases from state courts, Appendix C. The date on which the United States Court of Appeals decided my case was 3/11/2025. The date on which the highest state court decided my case was 11-7-2022. So about almost 3 years ago. The jurisdiction of this court is invoked under 28 U.S. Code, Section 1257A, and Article 3, Section 2, Clause 2 of the United States Constitution. Table of contents. I got my questions presented on page 1, my jurisdictional statement on pages 2 and 8, treaty constitutional provisions involved 2 and 3, statement of issues presented 9, statement of the case presented 9, statement of the case. Page 10. System violations, pages 10 and 11. Course of plea bargaining, page 11. Treaty violations and federal supremacy, page 11. Waiver of sovereign immunity, 11. Judicial immunity limitations, page 11. Relief requested, pages 11 and 12. Conclusion, page 12. Notice of void judgment and sworn affidavit, 13 through 22. Certificate of services is 23 to 26. Attachments and appendices, pages 27 and on. Appendix A contains the 8th Circuit Court orders. Appendix B contains Iowa and South Dakota District Court orders. Appendix C, State Supreme Court order violating speedy trial rights, the 1868 Fort Laramie Treaty. Appendix D has supporting affidavits and supplemental declarations. Appendix E contains exhibits of fabricated warrants, docket history, and etc. Table of authorities, the 1868 Fort Laramie Treaty, 18 U.S. Code, Titles 241. Maybe I could just show you guys. But this is the table of authorities here. So in the petition for the Supreme Court, these are my questions presented. And we'll go through this here today as much as possible, and then I will show my original state habeas corpus, the docket to that, and what I filed in that. So the questions presented are whether a state court judgment obtained through fabricated arrest warrants, lack of proper jurisdiction, and prosecutorial misconduct is void ab initio and violates the due process clause of the 14th Amendment. Question number 2 is whether the Fort Laramie Treaty of 1868 as a supreme law of the land under Article 6 of the U.S. Constitution preempts state jurisdiction over treaty beneficiaries and renders all state criminal proceedings against such individuals void. 3, whether systemic violations of the 6th Amendment, namely ineffective assistance of counsel, denial of a speedy trial, and coercive plea bargaining tactics and practices warrant vacatur of the conviction and reversal of lower court rulings. 4, whether judicial and prosecutorial immunity can shield officials who engage in actions outside the scope of lawful jurisdiction and commit fraud upon the court. 5, whether the state of South Dakota has waived sovereign immunity by codifying consent to suit and engaging in ultra-vires acts violating both federal law and treaty obligations. Parties to the proceeding, Myself, the petitioner Daniel Gomez, a lineal descendant of the Sioux Nation of Indians, Santee Sioux Tribe, and a treaty-protected individual under the 1868 Fort Laramie Treaty. And we the people. Respondents, Elk Point, Union County. Chief Justice of the South Dakota Supreme Court, Stephen R. Jensen, the State of South Dakota. Deputy Mike Palmer of the Union County Sheriff's Office. Melissa Larson, a clerk of court of the Union County Courthouse. Jerry Miller, prior prosecuting attorney of the State of South Dakota for Union County Elk Point. Michael J. McGill, a surrogate prosecutor appointed to represent and assist me in this case, who in turn assisted the state's prosecutor in obtaining a false confession and conviction. Roberto A. Lange, a United States District Court judge, federal judge. Nicholas A. Davis, a police officer with the North Sioux City Police Department. Chad Stroman with the Sioux City Police Department of Iowa. The City of Sioux City, the State of Iowa, the City of Sioux Falls, and probably some other ones I didn't list in there. But as long as my point gets across. The opinions of the United States Court of Appeals for the 8th Circuit, numbers 25-1114, number 25-1115, number 25-1512 has not yet been published or is attached in the appendix. The decision of the U.S. District Court for the District of South Dakota, case number 424 CV 04216, denying relief is also included in the appendix. Jurisdiction. This court has jurisdiction under 28 United States Code 1254, Section 1. The final judgment of the 8th Circuit was entered on 3-11-2025. Article 3, Section 2, Clause 2. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Constitutional and treaty provisions involved. United States Constitution, Article 6, Clause 2, the Supremacy Clause. Article 3, Section 2, Clause 2 is the jurisdiction. U.S. Constitution, 1st, 2nd, 4th, 5th, 6th, 7th, 8th, and 14th Amendments. The Treaty of Fort Laramie of 1868, Articles 1 through 16. The Speedy Trial Act, 18 United States Code, Sections 3161 et sequester. Title 18 U.S. Code, Sections 241 and 242, Conspiracy and Deprivation of Rights. 42 United States Code, 1983. Civil rights violations. Statement of the case. Petitioner seeks redress for a series of egregious constitutional violations, treaty breaches, and jurisdictional defects that render all state criminal proceedings against him void ab initio. The petitioner is a direct descendant of an enrolled Santee Sioux tribal member protected under the Fort Laramie Treaty of 1868. A binding instrument that preempts state authority over treaty beneficiaries. Despite this, the state of South Dakota fabricated arrest warrants without a valid charging instrument or lawful jurisdiction, subjecting petitioner to an unlawful detention, kidnapping conspiracy under color of law, coercive plea negotiations under threats and duress, and a fundamentally defective judicial process. Throughout the proceedings, petitioner was deprived and denied the effective assistance of counsel, speedy trials, the ability to confront and cross-examine witnesses, and other constitutional rights, was not timely brought to trial under the Speedy Trial Act or the Sixth Amendment, and faced judicial and prosecutorial misconduct, conduct that falls outside any legal immunity where jurisdiction was never lawfully established. The courts below dismissed these substantial claims, erroneously deferring to doctrines of immunity and finality, while ignoring constitutional and treaty violations that strike at the heart of fundamental justice and the supremacy of federal law. Reasons for granting the writ. This case presents urgent constitutional questions of national importance. Thanks for the likes. This court has long held that due process cannot be satisfied where criminal convictions rest upon fraudulent, jurisdictionless proceedings. A system that allows states to override the U.S. Constitution and federal treaty obligations threatens the foundational structure of law. 2. Treaty rights and federal preemption demands clarification. The Fort Laramie Treaty remains legally binding. Its preemptive force has been ignored by state courts, infringing on tribal sovereignty and federal supremacy. This court must resolve the scope of state power in light of treaty obligations. 3. Void judgments cannot be shielded by immunity. This court must determine whether doctrines of judicial and prosecutorial immunity can apply to ultra-vires actions arising from fabricated process, fraud, and acts taken absent jurisdiction. 4. The erosion of speedy trial rights and due process is a national crisis. The lower courts failed to remedy violations of petitioners' speedy trial rights, coercive plea bargaining, Miranda violations, and ineffective assistance of counsel, undermining the Sixth Amendment's core guarantees. 5. State waiver of sovereign immunity through codification must be addressed. South Dakota law expressly permits suit against state officials acting beyond their authority. The court must clarify the boundaries of state immunity where the state, by statute and action, has consented to liability. This petition presents weighty, constitutional, and treaty-based questions with national implications. The integrity of federal supremacy, tribal sovereignty, and due process demand review. Petitioner respectfully requests that this court grant the writ of certiorari and vacate the unlawful state proceedings. I, Daniel Gomez, a living man and natural person, hereby declare and assert my status and inherent rights as a lineal descendant and affiliated citizen of the Osheti-Shakowin Great Sioux Nation, specifically of the Santee Sioux tribe. My standing is not merely statutory, but rooted in ancestral birthright, indigenous sovereignty, and the supreme law of the land under Article 6 of the United States Constitution. 2. This declaration invokes the supreme authority of the 1868 Fort Laramie Treaty and a binding nation-to-nation agreement between the United States and the Sioux Nation. Said treaty, ratified by the United States Senate and codified under federal law, remains in full legal force and supersedes all conflicting state statutes, codes, or procedures under the Supremacy Clause. As a protected treaty beneficiary and a constitutional beneficiary, I am entitled to the full spectrum of inherent and unalienable rights preserved under the treaty, including but not limited to due process of law, liberty from unlawful seizure, recognition of tribal jurisdiction, and protection from sovereign governmental encroachments, including those perpetrated by state actors who have no lawful authority over treaty-protected persons or lands. The state of South Dakota, as a political subdivision of the United States, has no lawful jurisdiction to impose its codes, criminal procedures, or prosecutorial authority upon me in violation of the 1868 Fort Laramie Treaty. The United States Supreme Court has long held that treaties with native nations are the supreme law of the land, and that state interference with such treaties constitutes an ultra vires act, void ab initio. I further declare that my involuntary subjection to state criminal proceedings initiated through fabricated arrest warrants and prosecutorial misconduct, police brutality, assaults, and attempted assassinations constitutes a direct violation of my treaty-protected liberties and a breach of fiduciary duty owed by both state and federal actors under trust obligations established by federal Indian law, constitutional law, and international norms. The repeated acts of legal fraud, deprivation of rights under color of law, and systemic failure to honor the Fort Laramie Treaty render any and all legal processes executed by the state of South Dakota against me null, void, and without jurisdiction. I stand upon the law, natural, constitutional, and treaty, and invoke the lawful protections afforded to me under the Fort Laramie Treaty, the Constitution of the United States, and the sacred doctrines of indigenous sovereignty recognized in domestic and international law. This court has jurisdiction under 28 U.S. Code 1254 and Article 3, Section 2, Clause 2, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party. The Supreme Court shall have original jurisdiction. This court has jurisdiction under 28 U.S. Code Sections 1291 from a final order of the U.S. District Court for the District of South Dakota, case number 424, CV 04216. The lower courts dismissed petitioner's constitutional and treaty-based claims without proper adjudication on the merits. This appeal involves federal questions under 28 U.S. Code Section 1331 and Sections 1343, and constitutional deprivations actionable under 42 U.S. Code 1983, 1985, and 1986. Whether fabricated arrest warrants and criminal charges lacking lawful jurisdiction render the state judgment void ab initio. Whether petitioner's constitutional rights under the 1st, 2nd, 4th, 5th, 6th, 7th, 8th, and 14th Amendments were violated through unlawful arrest, prosecutorial misconduct, denial of counsel, and coercive plea bargaining. The underlying judgment is void ab initio due to fabricated criminal process, lack of jurisdiction, treaty violations, and systemic due process breaches. Judicial and prosecutorial immunity do not protect ultra vires acts committed outside lawful jurisdiction. South Dakota cannot invoke sovereign immunity where it has statutorily waived such protection. Further, the state's prosecution of a treaty-protected individual under invalid process violates both the U.S. Constitution and the Supremacy Clause. The district court erred in dismissing the matter on procedural grounds while ignoring substantial constitutional and legal defects in the underlying cases. Argument, void judgment and fabricated warrants. The judgment rendered against appellant is void, not voidable, due to the absence of a valid arrest warrant, indictment, or lawful jurisdiction. Fraud upon the court, including fabricated process, renders any resulting order a legal nullity. See Valley versus Northern Fire and Marine Insurance Company, 254 U.S. 348, 1920. United States versus Throckmorton, 98 U.S. 61. Judicial and prosecutorial misconduct. Appellant documented judicial and prosecutorial misconduct, including knowingly relying on void warrants, failure to verify jurisdiction, obstruction of exculpatory evidence, coercion of plea negotiations without probable cause. Such actions constitute fraud and constitutional violations beyond the scope of judicial immunity. See Forrester versus White, 484 United States 219. Stump versus Sparkman, 435 United States 349. Ineffective assistance of counsel. Appellant was deprived of effective representation as guaranteed by the Sixth Amendment as counsel failed to challenge jurisdiction, object to fabricated process, protect treaty rights, and demand a speedy trial. See Strickland versus Washington. Speedy Trial Act and Sixth Amendment violations. Petitioner's right to a speedy trial under 18 United States Code Section 3161 and the Sixth Amendment was violated by extensive delays and non-compliance with statutory deadlines. The failure to enforce speedy trial rights renders the conviction constitutionally infirm. See Barker versus Wingo. Coercive plea bargaining and Miranda violations. Appellant was coerced into plea bargaining under threat of enhanced charges and without full Miranda advisement, violating Fifth Amendment protections and established due process standards. See Brady versus United States. Treaty violations and federal supremacy. The 1868 Fort Laramie Treaty is supreme law under Article 6, preempting conflicting state actions. Petitioner is protected as a tribal descendant under this treaty, and any state court action against him absent federal authorization is null. See Worcester versus Georgia. Montoya versus United States. Waiver of sovereign immunity. South Dakota codified waiver of sovereign immunity through statutes authorizing civil rights claims against state officials who act outside lawful authority. See Ex parte Young, 209 United States 123. South Dakota codified law sections 21-32-16, 21-32A-1. Judicial immunity limitations. Immunity does not extend to acts taken in the absence of jurisdiction or with malicious intent. Fraudulent conduct, conspiracy to violate rights, and abuse of office are not judicial acts protected by law. See Pulliam versus Allen. Dennis versus Sparks. Relief requested. Appellant respectfully requests the following: reversal of the district court's dismissals, vacatur of the state court judgments as void ab initio, remand for full hearing on constitutional and treaty-based claims, declaratory judgment recognizing the supremacy of the 1868 Fort Laramie Treaty, injunctive relief against further state action violating treaty and constitutional rights. 6. Compensatory and punitive damages under 42 U.S.C. 1983, 1985, and 1986. This case implicates fundamental principles of due process, tribal sovereignty, and federal supremacy. The lower court's refusal to address the jurisdictional and treaty violations constitutes a miscarriage of justice. Appellant respectfully requests this Honorable Supreme Court reverse the district court's decision and remand for appropriate relief. The notice of void judgment. Notice of void judgment and sworn affidavit due to lack of jurisdiction, judicial misconduct, prosecutorial misconduct, and violation of oath of office, violation of rights. 2 Elk Point Union County Court. Regarding case numbers, State of South Dakota versus Gomez, 63C 0800237AO. South Dakota habeas, civil, 09-389. South Dakota versus Gomez, 63C 0800286AO. South Dakota Supreme Court case, counter complaints number 30364 and number 30100, filed in the South Dakota State Supreme Court. Notice to court and all parties involved. This notice is hereby issued to declare the judgment process rendered in the above referenced cases as void ab initio on the grounds of fraud, lack of jurisdiction, judicial misconduct, prosecutorial misconduct, and violation of oath of office by the presiding judicial officers of the courts. Lack of jurisdiction. The court is hereby notified that it acted or is acting outside its lawful authority by issuing a summons or judgment without proper jurisdiction over the matter and or parties involved. Jurisdiction is fundamental and must be established on the record at every stage of proceedings. Any judgment rendered without jurisdiction is null and void and lacks any legal effect. The following points summarize the lack of jurisdiction in this case. Melissa Larson, on June 7th, 2008, conspired with Deputy Palmer to impersonate a magistrate judge and issue a predated fabricated warrant of arrest after Deputy Palmer and Nicholas Davis made the arrest of June 7th, 2008. Said warrant was predated to February 2nd, 2006. Affidavit of myself under the penalty of perjury. I attest, swear, and affirm that the statements herein are true and declare and give notice comes now. I, petitioner, will testify substantially as follows and move the court to take judicial notice of the deprivation of rights under color of law conspiracy by North Sioux City Police Officer Nicholas Davis, Union County Clerk of Court Melissa Larson, Union County Sheriff Deputy Palmer, Supreme Court Judge Stephen R. Jensen, South Dakota State Senator Art Roosh, court-appointed surrogate prosecutors Michael J. McGill, Philip Peterson, John Slattery, and South Dakota State's Attorney Jerry Miller. All evidence of this conspiracy against rights and kidnapping at the Pronto Stop in North Sioux City, South Dakota on June 7, 2008. As such, kidnapping was committed in violation of Title 18 U.S. Code 241 and Title 18 U.S. Code 242, and of the 4th and 14th Amendments to the United States Constitution and the counterpart contained in the South Dakota State Constitution relating to unreasonable searches and seizures of persons and property, as well as SDCL 23A-2-2, which deals with the issuance and execution of warrants. Specifically, this notice refers to falsified police report by Nicholas Davis and fabricated forged warrant of arrest by Melissa Larson and Deputy Palmer. In the narrative case report prepared by Officer Nicholas A. Davis of the North Sioux City Police Department and consisting, among other things, of the call from Deputy Palmer to Melissa Larson regarding this conspiracy of kidnapping under color of law, which acts and omissions occurred and were conducted by Officer Davis on June 7, 2008, approximately 1:40 a.m. to 2 a.m. Under 18 United States Code 1201, a person is guilty of kidnapping who unlawfully seizes, confines, inveigles, decoys, kidnaps, abducts, or carries away and holds for ransom or reward or otherwise any person. The warrant was false and fabricated. Deputy Palmer, Nicholas Davis, Melissa Larson, Jerry Miller, Stephen Jensen, and the South Dakota State Bar conspired to deprive me of my rights, my life, and my liberty, subjecting me to a malicious prosecution and false imprisonment, holding me for several years in the South Dakota Department of Corrections under inmate ID 50853 and subsequently 52426. This conspiracy involves Sioux City Police Department officers and Woodbury County Jail officers. I posted a TikTok link on here for the recorded call to Manny Scarman, a parole agent with the Iowa Department of Corrections, asking about the existence of any warrants and Manny Scarman's response call. I was on parole in Iowa from December of 2006, and I flat timed in 2008, February of 2008. But I was continuously under their supervision or in their custody from October 12th of 2005 all the way until December of 2006. So there's no way I did anything on February 2nd of 2006. I was in custody. And furthermore, since the Department of Corrections of Iowa released me on parole during this alleged warrant that they had, the state of Iowa would never have released me on parole had there been an active warrant. So that right there is proof and evidence that there was no warrant in existence. So they fabricated that warrant. And when they did my background check, they noticed that I was in prison from March of 2006 till December. So they tried to predate that warrant to a time before I was in prison. But that record search doesn't count the time because you get that on a sentencing order that you was in jail prior to sending to prison. So you're in jail before you go to prison. That public records check doesn't turn out unless you get the transcripts from the court where the court gives you credit for time served for being in the county jail. Well, anyways, I put the other link in there for the response call from Manny Scarman, Department of Corrections, parole officer. The execution of the false and fabricated warrant was faulty because the forged warrant of arrest, contrary to the provisions in SDCL 23A-2-2, the fabrication of the day-only warrant to an anytime warrant happened orally and by the Union County Clerk of Court, Melissa Larson, who predated the warrant for February 2nd, 2006 on or about or after June 7th, 2008, rather than written by a magistrate judge as the South Dakota Codified Law provision requires. The statute reads as follows. It's Rule 4A. Warrant or summons issued on complaint, sworn oral testimony. Failure of defendant to respond to a summons, if it appears from a complaint or from an affidavit or affidavits filed with the complaint that there is probable cause to believe that an offense has been committed and that a particular person has committed it, a warrant for the arrest of that person, if requested by the prosecuting attorney, shall be issued to any officer authorized by law to execute it. If circumstances make it reasonable to do so in the absence of a written affidavit, an arrest warrant may be issued upon sworn oral testimony of a person who is not in the physical presence of a committing magistrate. If the committing magistrate is satisfied that probable cause exists for the issuance of the warrant, the sworn oral testimony may be communicated to the magistrate by telephone or other appropriate means and shall be recorded and transcribed. After transcription, the statement shall be certified by the magistrate and filed with the court. The statement shall be deemed to be an affidavit and complaint for purposes of this section. Upon the request of the prosecuting attorney, a summons instead of a warrant shall be used. More than one warrant or summons may be issued on the same complaint. If a defendant fails to appear in response to a summons, a warrant shall be issued. So I sent a copy of this to all the respondents, right? So I'm declaring under penalty of perjury and sworn oral testimony, and I'm doing it again here on TikTok. So I'm also requesting warrants be issued for them to come and be confronted with these accusations. And they can call each other as witnesses for the defense or whatever. They can try to cross-examine me. I don't know. What do you think they would do? All right. Emphasis added. A warrant did not exist in this case, but for Melissa Larson's fabricated one, tampering with records, creating one maliciously, which was a day-only arrest warrant for failure. So they told me it was a failure to appear. The lawyer told me that, and then I'm discovering that, well, I don't even have a warrant in this record for failing to appear. It's just a warrant with the charge on it. So that I couldn't fail to appear if they never issued a summons. So that's a denial of due process. If there wasn't a warrant in existence, then Iowa was guilty of denying me due process by failing to tell me that a warrant existed and allowing me the opportunity, like every other prisoner in Iowa got, to call this Union County and take care of it. So I was never notified of it. But again, I got the recorded call to Manny Scarman, and he did his little record search, and there was no information on a warrant. So, and I would most definitely charge Manny Scarman as well if he was in on it. No. Anyways, a day only arrest warrant for failure to appear, a misdemeanor. See? A misdemeanor. So when I get the next failure to appear, when I actually did fail to appear because I was in county jail again, and this time I knew I had the warrant, and I'm telling them, hey, I got court, and they didn't want to transfer me because South Dakota didn't issue a warrant. So they caused me to miss my court date, and then I was subsequently charged not with the misdemeanor failure to appear, but with the felony second-degree escape charge. Now, mind you, I had bonded out on that, right? And all this stuff is in here. All the evidence is in here. I got the bond paper I signed. I got the court order. And the notification they gave me that I would be charged with the failure to appear. And then when they go through and charge me with escape, that becomes a malicious prosecution. Now, in order for them to achieve me to get a false confession, they used my attorney that was supposed to assist me in my defense. And he turned around and all he did was assist the prosecution obtain a false conviction, a wrongful conviction. And I paid that lawyer. I paid him all the fines and restitutions for that. The amount exceeds $20, so my Seventh Amendment right to a civil jury trial is preserved. They can't waive that. That's an inalienable right. Because a failure to appear charge is a misdemeanor, then by statute, the warrant is day only and may only be converted into an anytime warrant by the signature of a judge. Black's Law Dictionary, revised 4th edition, defines endorse through reference to endorse as to write a name on the back of a paper or document. The context here is in negotiable instruments law, but given that the statute clearly says upon the warrant, the principle is the same. Endorsement as an authoritative signature upon a physical instrument, even if the clerk, acting as a magistrate, No, she wasn't acting, she was impersonating. Impersonating a magistrate somehow had the authority to issue or modify the warrant. Such modification in this case would not have been statutorily valid because it was not written on the document. Furthermore, Gomez was in the custody of Woodbury County Jail from October 12, 2005 through March 6, 2006, conducting a jury trial before the Honorable Dwayne E. Hoffmeyer of the Sioux City Courthouse. Present prosecuting attorney was Bridget Barnes, and defense counsel was Peter Van Etten. I was held in the custody of the Woodbury County Jail of Sioux City, Iowa, and on March 6, 2006 through December of 2006, I was held in Iowa Department of Corrections in Clarinda, Iowa, continuously. Given the invalidity and criminality of the false and fabricated warrant and execution of the seizure, my arrest was not valid. Therefore, a deprivation of rights under color of law, kidnapping in violation of Title 18 U.S. Code 241 and 242, a conspiracy by and through the Outpoint Union County employees and North Sioux City Police and subsequently Sioux City, Iowa Police Department and Chad Stroman of the Sioux City Police Department and Woodbury County on July 7th, 2008. Any unlawful seizures conducted pursuant thereto are similarly invalid, and the results of such, as well as any statements or false confessions made by myself to police or the courts while in custody from these unlawful seizures and kidnappings, are inadmissible as fruit of the poisonous tree. Wong Soon versus United States. For the reasons stated above, I move that this court enter an order vacating and exonerating Gomez of all crimes, and to order summons and warrants of arrest be issued for Larson, Davis, Jensen, McGill, Miller, Slattery, Peterson, and Palmer for the crimes of conspiracy to commit kidnapping under color of law, for the false arrests and false imprisonments and malicious prosecutions of June 7th, 2008 by Davis et al. And July 7th, 2008 by Chad Stroman et al. I want them and find that the defendants deprived Gomez of rights under color of law. Additional testimony regarding the kidnapping under color of law of my person, the false arrest, and conspiracy to deprive rights under color of law by Nicholas Davis et al. At the Pronto Stop in North Sioux City, South Dakota on June 7, 2008, and subsequent false arrest and kidnapping by Chad Stroman at 910 16th Street, as such acts were committed in Dakota Treaty territory in violation of federal and state laws. Treaties, the 4th, 5th, 6th, 8th, and 14th Amendments to the United States Constitution, and the counterparts contained in the South Dakota and Iowa state constitutions and state laws, which relate to, which relate to kidnappings and warrantless seizures and searches and seizures of persons. Specifically, this motion refers to acts and omissions specified and falsified in the narrative case report prepared by Nicholas Davis of the North Sioux City Police Department. These kidnappings were conducted by Nicholas Davis on June 7, 2008, and subsequently Chad Stroman of the Sioux City Police Department on July 7, 2008. The recent, well, it's not so recent anymore, but the South Dakota Supreme Court decision in State versus Hayen, 2008, SD 41, supports this information. In Hayen, a police officer stopped Wade Dustin Hayen because Officer Flogsted could not see the expiration date on the temporary license plate because it was blocked by objects in Hayen's pickup bed. Officer then walked by the temporary plate, able to see the date but not bothering to look at it. The officer, after dispelling his suspicion for the stop, proceeded to detain and investigate the subject. The officer was alerted to a warrant for Hayen's arrest and followed through with such, taking that opportunity to then search Hayen and his vehicle incident to the arrest. Finding illicit substances and paraphernalia, the circuit court granted a motion to suppress on the grounds that Flogsted's suspicion of criminal activity should have been allayed when he walked by the temporary plate and had the unimpeded ability to see the date. The officer had no further reasonable articulable suspicion that the person is involved in criminal activity unrelated to the traffic violation. Quoting State versus Ballard, officer, by his own admission, only stopped the vehicle to check the expiration date of the temporary plates, and neither did he look at the license plate, nor did he offer any other reason to extend his investigation beyond verifying the date on the temporary license. The court goes on to cite United States versus McSwain, the facts of which parallel those of my case, or the case of Hayen. McSwain had been pulled over because of an obscured expiration sticker on a temporary license. The officer saw as he approached the vehicle that the license was valid, but proceeded to question McSwain and seek to run his license. McSwain did not have a driver's license, but upon running his name through a check, the officer found out about numerous convictions and then sought permission to search the vehicle, which McSwain gave. The officer found a pew-pew, illicit substances, and a set of scales. Ultimately, McSwain prevailed in suppressing the evidence against him as fruit of an unlawful detention, for lack of any reasonable suspicion on the part of the officer that any criminal activity was happening or had happened. McSwain, at 560-62. The South Dakota court then drew the same conclusion in Hayen, noting that here, like in McSwain, the officer's actions in requesting Hayen's license and proof of insurance went beyond the limits of a lawful investigative stop. The officer could easily have looked at the license to satisfy his suspicions. Had he done so, it would have been clear that no violation had occurred or was occurring. At that point, his reason for detaining Hayen would have dissipated. He expressed no safety concern, he did not allege any observed violation of law, nor did he proffer any purpose for the continued stop. Without any further articulable suspicion of criminal activity, the extended detention violated Hayen's federal and state constitutional rights. Although there certainly are situations where an officer is permitted to make contact with the driver prior to investigating the purpose of the investigatory stop, in this situation there were none articulated. Therefore, the officer's request for Hayen's driver's license and proof of insurance constituted an unconstitutional detention, and the evidence garnered from the unlawful detention was properly suppressed. Like in McSwain and Hayen, Nicholas Davis had no reasonable, articulable suspicion to detain and investigate Daniel Gomez. His friend Angel, who did not have a driver's license, called Daniel to come pick him up at the Pronto gas station. Gomez showed up, and the police only learned that someone was coming to get Angel as Mr. Gomez was pulling up. The police did not know who was coming, nor was Angel involved in any criminal activity. The car I was driving was fully functional and proper to all appearances, with current registration, all lights working, etc. That's included insurance, I had a license, blinkers all worked, everything. A fact that's not in here is they didn't even pull over Angel. They pulled up to Angel as he was parked at a gas station waiting for me to show up. So Davis not only had no reasonable articulable suspicion to stop me or pull me over, but he didn't even make a valid stop with Angel. And to further that investigation into another car that showed up on scene, there's no, that's not reasonable. That's unreasonable through and through. Officer Davis had no reasonable articulable suspicion to investigate the vehicles or drivers. Because the investigations were not valid, neither was the subsequent arrest pursuant thereto. Therefore, any searches conducted as a result of the kidnapping and unlawful false arrest are similarly invalid, and any evidence gained from such, as well as any statements made by myself to police while in custody from this improper arrest, are inadmissible as fruit of the poisonous tree, as termed by Wong Soon versus United States. For the reasons set forth herein, I therefore move that the court suppress and vacate any convictions and all evidence and statements resulting from his June 7, 2008 arrest and false confession to the crime of escape, whether in or out of custody. 2. Judicial misconduct. The conduct of the presiding judicial officers in this case is hereby called into question for actions and decisions that exceed lawful judicial discretion and reflect misconduct, warranting voidance of the judgments. Judicial misconduct includes, but is not limited to, the following actions. Stephen Jensen was aware of the fabricated warrants and the malicious prosecution of second-degree escape, having himself entered the order stating methods and conditions of bond that did not include an order to return to custody. Thus, he willfully and knowingly engaged in the conspiracy to commit a deprivation of rights under color of law kidnapping. Judicial officers are held to the highest standard of integrity, and misconduct undermines the legitimacy of any judgment rendered under such circumstances. The violation of oath of office. The presiding judicial officers, Jensen and Roosh, took oaths to uphold the Constitution and to administer justice impartially. Actions or rulings that contravene this oath render any decision made under such circumstances void, as they violate fundamental principles of fairness, impartiality, and the due process rights of all parties. Stephen Jensen, being a party to these proceedings, failed to recuse himself in counter complaints number 30364 and number 30100 in the South Dakota State Supreme Court, which decisions or rulings were biased and prejudicial. Declaration that judgments are void ab initio. As a result of the aforementioned issues, these judgments are void and unenforceable. A void judgment is a nullity and is treated as if it never existed. Courts and officials must recognize that any actions taken based on this judgment are without legal effect. Under established case law and statutory provisions, a void judgment may be challenged at any time and in any court where it may be relied upon. This notice serves as an official declaration of the void status of the judgment and must be acknowledged as such by all entities attempting to enforce or act upon it. Request for immediate action. The court is hereby requested to vacate and dismiss any orders, warrants, or actions arising from the void judgments, cease all enforcement actions related to the judgment, acknowledge receipt of this notice, and provide confirmation of actions taken to remedy this matter within 15 days. The court lacked lawful jurisdiction over the subject matter and person in this case. A judgment rendered without jurisdiction is null and void and has no legal force or effect. Ex parte Roland, 104 U.S. 604. On or about June 7, 2008, Deputy Palmer and North Sioux City Police Officer Davis conspired with Melissa Larson, a clerk of court, to forge and fabricate a backdated arrest warrant predated to February 2, 2006, in violation of SDCL 23A-2-2, Title 18 U.S. Code 241-242, 42 U.S. Code 1983, and other federally recognized laws. Said warrant was not issued by a duly authorized magistrate judge, lacked sworn testimony or affidavit establishing probable cause, and was not legally endorsed in accordance with South Dakota Codified Law 23A-2-10. I was arrested on June 7, 2008 without lawful or valid warrant or probable cause, an act amounting to unlawful seizure and kidnapping under color of law in violation of the 4th and 14th Amendments to the U.S. Constitution. Further, I was continuously in custody in Iowa from October 12, 2005 through December 2006, negating any factual basis for a warrant dated February 2, 2006. These actions constitute an orchestrated deprivation of liberty by state actors, rendering all subsequent judicial proceedings unlawful and void. The presiding judicial officers, including but not limited to Justice Stephen R. Jensen, engaged in conduct exceeding lawful discretion by knowingly proceeding on the basis of a fabricated arrest warrant, issuing bond conditions while being fully aware that no lawful order for return to custody existed, failing to disclose or address material defects in the charging process. Judicial misconduct violates the principle of impartiality and renders decisions void. See Toomey v. Ohio. Prosecutorial misconduct. Defendant alleges prosecutorial misconduct by defense attorney Michael J. McGill, Philip Peterson, John Slattery, and prosecuting officer Jerry Miller, all of whom failed in their ethical and legal obligations to uphold due process and prosecute only upon lawful grounds, knowingly pursuing charges based on false reports and a forged arrest warrant, participating in the malicious prosecution and unlawful imprisonment of defendant for multiple years under inmate IDs 50853 and 52426, violation of oath of office. Officers of the court, including Justice Steve Jensen and Senator Arthur Roush, violated their constitutional oath by enabling or failing to prevent the conduct. The deprivation of constitutional rights, the use of fabricated legal instruments, biased and prejudicial rulings in related Supreme Court proceedings numbers 30100 and 30364, in which Justice Jensen failed to recuse despite a clear conflict of interest, inadmissibility of evidence, fruit of the poisonous tree. All statements, confessions, and evidence obtained as a result of the unlawful arrest and fabricated warrant are inadmissible under the exclusionary rule. See Wong Sun versus United States. Additionally, any proceedings flowing from this unlawful arrest, including subsequent charges and confessions, must be vacated as they derive from an unconstitutional seizure. Supporting precedent, State versus Hayen. The South Dakota Supreme Court in State v. Hayen invalidated a detention where the officer lacked reasonable articulable suspicion after a minor traffic stop. Similarly here, Officer Davis had no legal basis to detain, investigate, or arrest Defendant Gomez, rendering all subsequent searches and statements constitutionally invalid. Relief requested: declare all judgments, convictions, and warrants void ab initio due to lack of jurisdiction and constitutional violations. Order immediate dismissal and expungement of all related charges and proceedings. Cease all enforcement or execution of any orders, warrants, or judgments in the above captioned matters. Issue summons and arrest warrants for all public officials and officers involved in the conspiracy to deprive myself of his constitutional rights under applicable state and federal law. Provide written acknowledgement of this notice and actions taken thereon within 15 days of receipt. Restitution, compensatory damages, punitive damage, nominal damages, treble damages. That's also notarized. This is my certificate of service. I served all these people with copies of that stuff. So if Digital Ally is in there, Solicitor General of the United States. Also declared under penalty of perjury. Appendix A is the federal court orders. The 8th Circuit Court of Appeal court orders. Appendix B. It's got the federal court orders for these two cases. There's a few different defendants in there, but I pretty much got the gist. I was trying to sue Axon Mobile, or Axon Enterprises for providing them the kidnapping tools, the tasers and things like that, and also the body cameras to record these criminal acts, the dash cameras and things like that. Not so much to sue them for, maybe kind of, but I wanted the evidence. I wanted the body cam evidence because the police did not retain that evidence. So I don't know if Axon Enterprises has some type of big database that when they upload it, it still stays somewhere. And so we'll get past that. This is the federal judgment. Skip some of this because when you appeal a thing, you give no deference, you give no respect to the orders, the court that you're appealing from. The orders get no respect. There's case law on that. An appellate court gives no deference to a lower court's orders or findings or conclusions, none of their summaries, none of that. So all these court orders, they get no respect. Rules of appellate procedure. There's that judge there, Lawrence L. Pearson. Order denying request for petitioner for writ of habeas corpus. This was a state court order. And that was a state court. And then it got appealed to this case number. And then there's Steven Jensen again. Why would he do that? So they said that I haven't provided any proof that the state adopted an unconstitutional policy. Well, this is the Supreme Court's order authorizing the deprivation of our speedy trial rights. Chief Justice of the Supreme Court. All right, so this was a part of a grievance I did. I filed a grievance. They had case law on that they could not do that. The denial of speedy trial rights didn't pertain to people that were in custody in the county jail. It only pertained to people that were out on PR bonds or bonded out. So when you're in custody, that judicial emergency didn't count towards that. Yet they had all of us in there just sitting us there. All right. The South Dakota Constitution prohibits any power of suspending laws unless exercised by the legislature or its authority. Only the legislature can suspend a law. Article 6, Section 21. This section of the South Dakota Constitution explicitly states, no power of suspending laws shall be exercised unless by the legislature. So this is a judge exercising the power of suspending a law. Order suspending that law, 23A 44-51. And anybody who followed this unconstitutional order, they're all guilty of the deprivation of rights. Legislative authority. This means that the power to suspend laws is reserved to the South Dakota legislature or to bodies or officials authorized by the legislature. No executive power to suspend laws. The South Dakota Constitution does not grant the governor or any other executive branch official the power to suspend laws independently of legislative action. South Dakota legislature. Unconstitutional state actions void. Enforcement of unconstitutional policies is prohibited. enforcement of this unconstitutional policy was prohibited. The office of the President of the United States. This was a treaty. The 1868 treaty. Article 1, paragraph 2. If bad men... No. Where is it at? Article 1. I didn't highlight it. Oh, Article 1. That'd be Section 1, Section 2, Section 3, Section 4, I guess. Article 1. I don't know, sentence 4. If bad men among the whites or among other people subject to the authority of the United States shall commit any wrong upon the person or property of the Indians, the United States will, upon proof made to the agent and forwarded to the Commissioner of Indian Affairs at Washington City, proceed at once to cause the offender to be arrested and punished according to the laws of the United States, and also reimburse the injured person for the losses sustained. That's a treaty text. I gave them the whole entire treaty. There's evidence in there. And supporting documents, affidavits, supplemental declarations, documenting and reporting the repeated violations and deprivations. This is Appendix D. My brief in support is in there. This was handwritten stuff. And see all these cases over here? This document was filed in all these cases. They kept giving me a warning, this case is closed, this case is closed. Well, it's not closed if it's part of a continuing criminal enterprise, right? I entered this brief on what was filed on January 18th of 2022. So it's been in court procedure, so court processes, what's the time tolling they like to use? Pending decisions and all that. So I probably still got 2.5 years left on this. I was arrested October 1st, 2021, arraigned and advised on court record of constitutional rights to speedy trial and an attorney, and provided with a court-ordered scheduling order and deadlines pursuant to SDCL 15-6-40A, acknowledged understanding and demanded a speedy trial from the court-appointed attorneys. I named a few on there. Pursuant to SDCL 15-6-38B, to which the attorneys did repeatedly attempt to coerce Gomez to involuntarily waive speedy trial, Fifth Amendment rights against self-incrimination, and plead guilty against my interest of exercising constitutional rights to due process, the preponderance of innocence until proven guilty beyond a reasonable doubt. Attorneys et al. Misrepresented Gomez, breaching contractual duties and obligations of attorney to client. See Attachment 1. Attorneys reserved his or her effective representation and assistance services exclusively for the state's attorney's office and only attempted to secure a guilty conviction on behalf of the Minnehaha County State's Attorney's Office and the state of South Dakota, depriving the right to lawyer. State of South Dakota, by and through its several employees of the state, to include Judge Powell, Judge Zell, private lawyers, and state's attorneys, and the state court-appointed attorneys, do act in unison in an unwritten policy, custom, or practice violating several constitutional rights that the accused shall enjoy. South Dakota Codified Law 23A-44-5.1, 4B5. Prejudice to Gomez. Violating Title 18 U.S. Code 241 and 242. I demanded speedy trial pursuant to Title 28, Chapters 89, Sections 1443, Civil Rights Cases 1 and 2, and pursuant to Title 18, Chapter 208, Section 3161, A, B, C, 1C. See Kurtenbach versus Hole, November 3rd, 2020. The Sixth Amendment to the U.S. Constitution guarantees an accused a speedy trial, which right is enforced against the states under the 14th Amendment. Coper versus North Carolina, 386, United States 213. Verify. Thanks for joining. Tap the screen if you like this. Tap, 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 and share. Coper versus North Carolina, 386, United States 213. Upon the petitioner or the defendant's demand, the state has a constitutional duty to make a diligently good faith effort to bring him before the circuit court for trial. Smith versus Huey. South Dakota Speedy Trial Act, Raines versus Hollingsworth, to which I asked this court to issue an order disqualifying all judges of the Second Judicial Circuit Court pursuant to South Dakota Codified Law 15-12-21.1, SDCL 15-12-34, and South Dakota Codified Law 15-12-37. I bring this brief in support pursuant to SDCL 15-12-27. For purposes of First Amendment, law gives judges, lawyers, and other court or state officials as persons or courts as institutions no greater immunity from criticism than other persons or institutions. Interest in protecting reputation from injury is insufficient reason for repressing speech that would otherwise be free. And interest in protecting institutional reputation of courts is entitled to no greater weight in constitutional scale. Landmark Communications Incorporated versus Virginia, 1978. Gomez and 420 CV 04151 and Black Bear, case number 421 CV 04176, have provided sufficient evidence for Monell claim municipal liability. United States District Court, Second Circuit, Marchand versus Simonson. 14th Amendment, substantive due process, state law harassment. 3 possible grounds for Monell claims against municipal defendants. 1, the municipality adopted an unconstitutional policy. We showed you that, right? The municipality adopted an unconstitutional policy, right here. Signed by a judge, court seal, and the Supreme Court of the state of South Dakota orders suspending the law. They adopted this right here is the policy. The municipality adopted an unconstitutional policy. South Dakota Supreme Court judge order waiving speedy trial rights due to COVID pandemic. Right here. It's in my hand. I provided this. That's one ground right here. This alone right here is one ground for that. The municipality failed to adequately train its licensed attorneys on constitutional rights of defendants. 3, the municipality failed to adequately supervise or discipline its judicial employees and court officers, agents, lawyers, and judges. The municipality, this whole state of South Dakota, who exercises supervision over the state courts? The federal courts, the Supreme Courts. This court is obligated to draw the most favorable inferences that pro se litigant plaintiff's complaint supports. Now that's another case. Somebody else, I shared a video yesterday with that, but there's Chavez versus Chapins down here. Chavez versus Chapins. This court is obligated to draw the most favorable inferences. So that's that liberal construction. Pro se pleadings are held to a less stringent standard. For respondent superior, you can cite these cases here. You can look up these ones. United States versus Stringer. See United States Department of Justice Criminal Resources Manual 162 3A46. federal prosecution of business organizations. Again, the Solicitor General got all this. Rule 1.4, right. Dilatory practices. The appendix to South Dakota Rules of Professional Conduct. Comment, breach of fiduciary duty. 1, 2, 3. Rule 3.2, expediting litigation. Dilatory practices. Rule 1.4, communication. See attached rules and laws. Let's see. Constitutional challenge. The habitual offender, Part 2, criminal information is a direct assault on the Constitution's protections against the double jeopardy clause. A malicious prosecution by the states with deliberate indifference to the protections, privileges, and immunities secured by the Constitution by state and municipal actors, to include but not limited to judges, lawyers, jailers, wardens, parole officers, etc. Title 18 U.S. Code 241 through 242, under color of law. Article 4, Section 1 of the U.S. Constitution. The full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved. Comes now, State of South Dakota attempts to reclassify criminal history of one state located within Dakota Territory as a felony, and another state also located within Dakota Territory, a judicially established treaty territory ratified by Congress and contained in the Fort Laramie Treaty, where the act was not done within the state's jurisdiction to grant South Dakota jurisdiction to reclassify an offense in another state's jurisdiction, does violate Article 4, Section 1 of the U.S. Constitution, denying the full faith and credit to the records of Iowa within South Dakota state courts. So what they were doing there, they were reclassifying misdemeanors in the state of Iowa and saying, well, if you had committed them in the state of South Dakota, those are considered felonies. So for habitual criminal felony purposes, you're looking at life. Coercive plea bargaining tactics. Well, even if it was a misdemeanor over there, it's a felony over here if you had done that over here. So it counts as a 3 strikes a felony conviction. Now you're looking at life. Okay? I'm not lying. Not fucking lying. That's what they told me. State of South Dakota does not give full faith and credit contained within its own state's records, public acts, and least of all its judicial proceedings. A living witness is before you reading this supplemental testimonial. I was maliciously prosecuted by State's Attorney Jerry Miller of Union County, Elk Point, South Dakota, of second-degree escape. I declare actual innocence of escape. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary are notwithstanding. Constitutional Amendment 1. Congress shall make no law abridging the freedom of speech or the right of the people to peacefully assemble and to petition for a redress of grievances. South Dakota state legislatures lobbied for and enacted South Dakota Codified Law, Chapters 22-7-8.1, the habitual criminal statutes and others contained under that title and chapter, with deliberate indifference to the protections and immunities secured by the U.S. Constitution in violation of Title 18 U.S. Code 241, violation of Title 18 U.S. Code 241, conspiracy against rights, and Title 18 U.S. Code 242, deprivation of rights under color of law. Constitutional Amendment 5, which states in pertinent part, nor shall any person be subject for the same offense to be twice put in jeopardy, nor shall be compelled under threat, duress, or coercion to, in any criminal case, to be a witness against his or herself. A coerced guilty plea, a false confession, is you being a witness against yourself. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken. Minnehaha County State's Attorney's Office and the state, by and through its several employees, are deliberately indifferent to and knowingly and willfully engaged in the deprivation of rights under color of law, a direct assault on the U.S. Constitution. Constitutional Amendment 6. By depriving all accused criminal defendants held on excessive bail in Minnehaha County Jail of the rights and privileges secured by the Constitution, Amendment 6 states, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of their state and district where the crime shall have been committed. Habitual criminal information holds information of prior convictions occurring out of state. To be confronted with the witnesses against him, her, to have compulsory process for obtaining witnesses in his or her favor, and to have the assistance of a lawyer for his defense, not for his prosecution. You have the right to the effective assistance of a lawyer for your defense. not for the assistance of your conviction. That part. With today's technology and infrastructure, 180 days is no longer considered a speedy trial. 90 days is considerably a speedy trial, argumentatively. 45 days, 30 days, 2 weeks is probably a speedy trial. But the lawyers ain't even competent to hold a speedy trial within 180 days. So it's not the technology and the infrastructure that it is. It's the fact that they're appointing these defective lawyers, these surrogate prosecutors. They have dreams and ambitions of being prosecutors and see, they don't want it to be defense lawyers. So they're false advertising. They're impersonating defense lawyers and carrying out the duties of a prosecutor. If that isn't fraud in itself, I don't know. I'd like a second opinion, concurring or otherwise. To which the state of South Dakota, by and through its several agencies, employees, Minnehaha County State's Attorney's Office, Minnehaha County Public Defender's Office, Minnehaha County Public Advocate's Office, law enforcement officers and judges are privy to and guilty by association. They do collectively violate and deprive the rights of the people. State of South Dakota and others have customs, policies, or practices that deprives people of several rights and privileges, if not all of them, to include customarily appointing defective counsel to assist the accused in every instance. The state has failed to rid the county's offices of such defective employees and reappoint defective counsel to other defendants, allowing defective and ineffective legal agents to abandon their duties. It is a fraudulent scheme bordering on a racketeer influenced corrupt organization operating as a court of law. The defective assistants that are customarily appointed by the states render no assistance whatsoever to an accused. The court-appointed lawyers, the privately retained lawyers, customarily claim that their assistance is beyond the scope of service. It appears they are issued inadequate scopes and are in need of pay cuts and major sanctions, discipline, and re-education to bring the effective assistance within the scope of services and duties. Or just disbar them from practicing law. Make them get a real job. I encourage lawyers to declare to the state's attorneys that negotiating guilty confessions on the state's behalf is beyond their scope of duties, as it infringes on the right against self-incrimination. As defendants, court-appointed assistant lawyers are required to assist in his defense rather than assist the state obtain guilty convictions. I request the Department of Education be informed immediately, as well as the American Bar Association and any other state bars. South Dakota Codified Law 22-7-8.1, the Information Part 2 habitual criminal enacted by South Dakota legislatures, contrary to U.S. Constitutional Amendment 7, which reads in part, the right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States. To which Minnehaha County State's Attorney's Office is attempting to re-examine prior convictions, which were tried by jury. They put I went to a jury trial on the convictions they're talking about. I went to a jury trial on one case. That one case resulted in like 2 felony convictions. They separated those 2 felony convictions and counted them as 2 separate strikes. They're not allowed to do that. In their statutory law, they cannot do that. So any conviction arising on that March 6th, 2006 thing that they got, that was all one case. They could only use that whole entire case as one strike. You have to have separate cases with separate convictions for it to count as an extra strike. For felonies, anyways. Now, what they were doing was they were saying I had like a bunch, those misdemeanors count as felonies over here. And that's where the coercive tactic came in to obtain an involuntary guilty plea. And I had no way to reference or cross-check and check and verify what they were telling me. They wouldn't give me the law books. That's called double jeopardy violation. That's called a malicious prosecution. They know the law. They're presumed to know the law. So when they're misstating the law, that's misleading information. So if they mislead you into something and because of that misleading information you signed a contract, that nulls and voids it there too. So if they've been abusing the law to a certain extent like this, I think the law is pretty much null and void, even if it contradicts the Constitution anyways, it's null and void. But when stuff like this is coming out, and they can't deny that shit, it's all on the record. The right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States. This was a writing I did in this case. This is a copy of it, but you can see the original nice and clear up here on 421 CV 04179, document 32, filed on January 18th, 2022, page 5 of 8. To which the county state's attorney's offices are attempting to re-examine prior convictions, putting in jeopardy twice for a previous conviction, to continue allowing the South Dakota state courts to re-indict, re-examine, recharge, and impose any penalty based on prior offenses violates this Constitution and is a severe miscarriage of justice. Habitual offender statutes and habitual offender statutes and others in that chapter should be scrubbed and deleted from the law books and all references made, as they were enacted by legislatures in violation of the Title 18 U.S. Code 241 and 242, and against the rights and privileges and immunities secured by the Constitution. Deprivation of rights. South Dakota has adopted a custom, policy, practice, or law that violates the Constitution, that being habitual offender laws, are contrary to the U.S. Constitution and are not withstanding. Take judicial notice of Section 1, Legislative Powers, Notes to Decisions, in general, miscellaneous. Legislature can enact substantive rules of law. United States versus Lockheed. Oil and gas, something. A party seeking to persuade the court that reconsideration is appropriate bears the burden of demonstrating one of the following: an intervening change in the controlling laws. Supreme law of the land is constitutional. Double jeopardy law is controlling law. The availability of new evidence that was not available when the court issued its order. New evidence being my statements herein. The what do you call those warrants, the order suspending the speedy trial, right? That's new evidence, right? See also Crimson versus New Jersey Department of Education. The purpose of reconsideration is to correct manifest errors of law or fact to prevent injustice. The court will grant motion for consideration only where its prior decision has overlooked a factual or legal issue that may alter disposition. Andreco versus Sunrise Senior Living Incorporated. On this one, I requested the court to grant injunctive relief, barring state from violating double jeopardy protections. 2, delete Part 2 habitual offender laws from records as it was enacted contrary to Constitution. 3, remove from office and impeach any legislator, judge, lawyer, prosecutor who willfully engaged in the unconstitutional law. Fine and imprison under Title 18 U.S. Code 241 and 242. 4, I want monetary compensation to aggrieved parties of the unconstitutional law and reduced sentences for any convicted felon on the Part 2. Order the states to expunge prior convictions from records upon completion of sentence. 7, delete and discontinue the practice of dismissals without prejudice, as a dismissal without prejudice is prejudicial in and of itself. 8, discharge from duty and disbar from practicing law, private retained or court-appointed ineffective counsel for breach of fiduciary and breach of contract obligations. State of South Dakota, by and through its several employees, have adopted a custom, policy, or practice that violates the constitutional rights to a speedy trial, in that an unknown judge has issued an unconstitutional order waiving speedy trial rights and is guilty of Title 18 U.S. Code 241. I didn't know about that order. I knew about the order, but I didn't have a copy of it at the time I wrote this and submitted this. But I was able to obtain that document. It was very, very hard to get that. It was like pulling teeth, man, from a lion with no sedatives. No, Elm Wolf. 3 charges out of the same night, and prosecuting separately is called double jeopardy. No, they don't prosecute them separately. They prosecute them the same. So you go to trial on one case, and the jury has to find you guilty of each of the charges. That's not double jeopardy. Now, if you go to prison and you satisfy your sentence, you complete your sentence, and you get out, and the prosecutor, you get a new charge down the road of, let's say, a DUI. Third, they charge you with a felony. Now they're going to bring up those prior convictions that you went to jury trial on and got convicted on, and they're going to say, well, you got 3 charges there, so that counts as 3 strikes. No, that's all one case. It counts as 1 strike for the habitual offender purposes. Now you got a new DUI, DUI third, DUI fourth, or whatever it is that enhances it to a felony. Now, they can only use that habitual offender one time once they hit you with the offender. So now let's say, like I did, I bonded out. Now they're talking about you got this case for whatever they arrested you for, and now you got this other case of second-degree escape. 2 separate case numbers. They're going back and they're using the same prior convictions that you went to trial on 6 years ago. They're saying, oh, well, now you're a habitual criminal, so we're going to charge you with the habitual information on this new case and on this other new case. They can't do that. That's double jeopardy. They can't keep charging you as a habitual criminal over and over and over. They can only use the enhancement one time. So that's now you're looking at 25 years on this one. You're looking at another 25 over here, or now you're looking at a lifetime penalty. So now they're talking about two consecutive life sentences or concurrent life sentences. However, that it's up to the judge, and that's called coercion. That's under threats, duress, and coercion when they're misstating the law to you. Title 18 U.S. Code 241. The meeting of the mind occurred when subordinate actors advocated and blindly followed under the judge's unconstitutional order, which was granted with the excuse of COVID-19, where subordinate actors utilized it abusively, delaying speedy trials unreasonably for any and all random excuses except COVID-19 pandemic. The Minnehaha County State's attorneys, advocates, defenders, and several private practice law firms and several judges acting in unison did knowingly and willingly deprive pretrial detainees and unconvicted defendants of several constitutional rights prior to COVID-19, during COVID-19, and left unchecked and undisciplined would continue to do so. State Bar of South Dakota has a policy fining and suspending from practicing law its members. Why not use it? I'm all for it. Let them go pick up trash. Let them do some community service, some real community service. You know, they be getting kids to do all kinds of community service all over. I'll let these guys do some community service for once. Title 18 U.S. Code 241, 242 has a range of sanctions ranging from 1 year to life, depending on severity and extent of violations. And it has a capital punishment in there. So this was submitted in there as evidence as well. Comes now, pro se petitioner enters this writ of habeas corpus challenging the constitutionality of my pretrial detention to the judicial officer of said court. So what I did with this one, this is the copy I sent to the federal court. So when I wrote it out, I left this in pencil because I made 3 copies of this. And then I went up here and I wrote Minnehaha County State Court, 2nd Judicial Circuit Court. So I sent a copy of this to the federal court, the state court, and then I appealed the state court, and I told the federal courts that I was doing that to hold off on so that they could take judicial notice of it and see how the state court reacted to all of this. To the judicial officer of said court, in the above style numbered cause, moves this court to grant this petition, and in doing so would demonstrate the following: ineffective assistance of counsel, 23A-46-6, writ not precluded. I was currently in the custody in violation of the United States Constitution, South Dakota State Constitution, and several South Dakota State statutes codified therein, held in the custody at the Minnehaha County Jail under ID number 2369118 for the false allegation of assault on law enforcement officers Aaron Bobier and Justin Ritter. See petitioner's counterclaim in District of South Dakota Federal Court, Gomez versus Ritter et al., case number 421 CV 04179, in violation of the 4th Amendment. I asserted my rights under the 4th, 5th, 6th, 8th, and 14th Amendments of the U.S. Constitution and South Dakota Codified Law 16-18, the powers and duties of an attorney, Rules 1.1, 1.2, 1.3, 1.4, and Rule 3.2, expediting litigation. I demanded a speedy trial pursuant to my Sixth Amendment right under the U.S. Constitution and South Dakota State Constitution, Article 6, Section 7. South Dakota Codified Law 15-6-38B. South Dakota Law 23A-44-5.1. South Dakota Speedy Trial Act, and the 180-day rule. I have exhausted state remedies on court record before Presiding Judicial Officer Robin Howman on May 27, 2022, between 3 and 4 p.m. This petition is properly before this court pursuant to 28 U.S.C. 2243. This court must order my release. South Dakota Codified Law 23A-44-5.1. If defendant is not brought to trial before the running of time for trial, prejudice to the defendant is presumed, and the defendant shall be entitled to a dismissal with prejudice. South Dakota Constitution, Article 6, Section 1s, 4, and 5. South Dakota Constitution, Article 6, Section 7. In all criminal prosecutions, the accused shall have the right to a speedy public trial, reaffirmed in Title 18, Section 3161. SDCL 23A-44-5.1. South Dakota's 180-day rule. Thus, the South Dakota Supreme Court is in violation of its oath to uphold the U.S. Constitution and the South Dakota State Constitution, invoking the protections against unconstitutional state provisions in SDCL 1-1A-1 through 1-1A-4. This court, pursuant to SDCL 15-6-40A, issued a scheduling order with deadlines to which this court, its officers, and appointed counsel are in contempt of in that they did not adhere to it. Also, SDCL 15-6-40C. In the absence of the adverse party, a court may proceed with the party's case and take a dismissal of the complaint. Under SDCL 22-30A-A. So, if they're charging you with something and you got a court date and the accuser doesn't show up, the police officers never showed up, they never showed up to court, they were absent. They didn't come back to respond to any of my motions to dismiss. The adverse party was not present at any of these proceedings, at any of these court cases. So the state court erred in not dismissing it. Under South Dakota Codified Law 22-30A-16-2, I had an honest and reasonable claim of right to property as an affirmative defense. I was unreasonably seized, contrary to the Fourth Amendment, deprived of liberty and property without due process of law. A statement of facts. On October 1st, 2021, domestic terrorist officers of the Sioux Falls Police Department responded to a call for a standby police presence for myself to retrieve my personal belongings from my residence, where I had a right to be under a contract for deed, entered into with the seller, Wade Randall. See case number 421 CV 04179, document 1-1, filed 11/3/2021, page 10 of 68, page ID number 21. Contempt of court, no contact order. Worth noting, a no contact order was for a specific person. Officers Ritter and Bobier arrived, and Daniel has a right to be free from excessive force, police brutality. Said officers did trespass upon Daniel Gomez's dwelling. See South Dakota Codified Law 22-18-4.2. They did assault with dangerous weapons, giving rise to my right to defend my life under South Dakota Constitution, Article 6, Section 1, and under SDCL 22-18-4, and South Dakota Codified Law 22-18-4.1, Sections 1 and 2. I was on my property for the lawful purpose of retrieving my work tools, ID, and other necessities, including my evidence. Officers' conduct and actions were disproportionate and inconsistent with their training and did put myself in fear of imminent death under SDCL 22-18-4.3. Under South Dakota Codified Law 22-18-4.6, my use of force was reasonable when necessary to prevent or terminate another's trespass on or interference with my possessing my real property. Wherefore, the weight of the state's evidence against me in this regard is outweighed by my evidence showing the officers provoked the use of force against themselves when they feloniously assaulted me, thus falling under South Dakota Codified Law 22-18-4.9, Section 2. Furthermore, in the case of State v. Means, March 14, 1979, South Dakota Codified Law 23-34-2 states, if a criminal action, unless postponed by defendant's application, is not brought to trial, the court must order the prosecution dismissed. I cited the following case law and supporting arguments. 1, 2011 U.S. District Lexus Reynolds v. Graham, August 11, 2011. If a police officer intentionally or recklessly provokes a violent confrontation, they're liable to get injured and liable for damages. Here in this case, officers intentionally committed a kidnapping under color of law and felony assault in violation of Title 18 U.S. Code, Section 113. Why is there a blank page? What page was that? That's 5. Oh, shit, that's not extra pages in there. All right. This was all handwritten shit. The courts accept handwritten shit. This shit don't have to be certain font size. It don't have to be nothing. You can handwrite these things out, man. Don't let them clerks fool you. This was filed with no problem. This was filed with no problem. 2021, South Dakota 57. People ex relinquish. N.A. That was a case of a minor. There can be no doubt that officers are permitted to use force when their safety is threatened. Absent a threat to their safety, they're not supposed to use force. Here, Petitioner Gomez, I did nothing to threaten officer safety that could reasonably justify the use of force employed by Justin Ritter and Aaron Bobier. My peaceful disobedience to officers does not, as a matter of law, give right to officers to beat me, to defend themselves. See case State versus Bogenreef. United States ex relinquish means versus Solem. A policeman's use of force becomes unlawful when it reasonably appeared as an attack squad. As it reasonably appeared and felt to me as an attempted unaliving on October 1st, 2021 at my residence here. Means versus Solem. South Dakota law makes no distinction among those allowed to defend themselves and coming to the defense of another. Now South Dakota State attempts to overrule and adopt a law that one cannot defend himself against police brutality and that I must allow officers to beat me until they tire themselves out. I don't consent to that. I don't consent to that. Supreme Court of South Dakota and State versus Lucky. The Supreme Court of South Dakota has accepted the objective reasonable person standard. It's prejudicial to say the objective officer on scene, the reasonable officer on scene. It's creates a prejudice in the minds of a potential jury pool. The objective reasonable person standard. So that right there removes the insinuation that the only reasonable person on scene is that of an officer. So if they say the reasonable officer on scene in a jury instruction, it's a prejudicial jury instruction because it plants this seed of thought in this jury that, oh, well, who's the reasonable officer? And then they're just focusing on all these officers that come up and testify. If they limit that jury instruction is a good instruction, but if they limit it to a reasonable person, so that could include anybody that is or is not an officer. What was the objective reasonableness of the people on scene? My objective was to obtain my court documents and the evidence that I had here on this stuff here. I was trying to get this stuff and my belongings. So that was my objective. What was his objective? His objective was not reasonable because it was to obstruct me from getting this evidence out of the house on an ongoing case I had, to deprive me of my property. That was his objective. So here my reasonable objective was to retrieve my property that I am lawfully and rightfully entitled to. I don't know. They can see the original document. There's some stuff in here the printer didn't pick up, some writing here. But probably it's on the original document. SDCL 23A-3-5 provides in part that no person shall subject an arrested person to more physical restraint than is reasonably necessary to effect a lawful arrest, a reasonable seizure. Use of excessive force is impermissible even when during a lawful arrest. Here, I did not provoke an assault, nor did I instigate violence, nor provoke a conflict. Supreme Court, South Dakota, 1952. State versus Meyer. It is lawful for a person who is being assaulted to stand his ground and defend himself. That's all I did. I was being assaulted and I lawfully defended myself. 38 South Dakota 159, State versus Bell. When a man is assaulted on his own premises, he may arm himself if he can, and standing upon his own doorstep, he may defend himself against all assailants. There's no distinction based on employment as a police officer. If an officer acting under color of law commits a forcible felony, then as a citizen or man, one is justified in defending against such attack. Home security video footage will show an aggravated felony assault by individuals attacking myself on my porch. That video is posted. I posted it several times. A couple people complained they got it taken down for showing violence, but it's still up there. So within the first 6 videos I ever posted. Supreme Court of South Dakota, State versus Spotted Horse. I wish to point out that this assault arrest was reckless. This Native American was assaulted and arrested on private property, his own. I would point out the same reckless actions of police officers in my case. State versus Lepwin. After careful examination of all the evidence in the case, we are clearly of the opinion that defendant was fully justified in this case in believing that officers either intended to unalive him at the time or was making a felony assault upon him calculated to do great injury. Means versus Solomon again. Alterations from the original. However, the officers were not authorized to use unlawful force in a standby assist call. In assisting a protected party, give myself the clothes where I awaited officers' arrival. I remained seated on my porch. If the police were the aggressors in assaulting myself, it was unlawful and certainly uninvited by peaceful disobedience, peaceful protest, and peaceful demonstration against an unreasonable seizure of my property and person absent due process of law, violating the 4th Amendment of U.S. Constitution. Therefore, the fact that I peacefully and lawfully remained seated on my porch at my home where I have a right to be in non-compliance of an officer's order could not justify the officer's aggravating felony assault in the misuse of PD-issued self-defensive controlled electronic weapons in an offensive criminal manner, manifesting an extreme indifference to the value of human life that cannot be viewed as acts committed in the performance of their official duties. Those officers were responding to a call for me to retrieve my clothing and my property. See State versus Mulvihill. Citations in 77 ALR 3D 281 through 300. The right to resist excessive force used in accomplishing arrest. See the Castle Doctrine. South Dakota Stand Your Ground Laws. Title 18 U.S. Code 241-242. Deprivation of rights and conspiracy against rights. Part 5. Speedy jury trial violations. 6th and 14th Amendment. The 6th Amendment to the U.S. guarantees an accused a speedy trial. You got Cooper versus North Carolina. Here, Gomez has made repeated demands for speedy trial to Caleb Paulson, Manny DeCastro, the jail administration, court administration, to which, upon defendant's demand, the state, the courts, and defense counsel have a constitutional duty to make a diligently good faith effort to bring me before the circuit court for trial. Smith versus Huey. See attached exhibits of grievances pertaining to speedy trial demands. My mother has passed away due to cancer. She intended to testify on my behalf. The appointed assistant, Caleb Paulson, was notified of the fact that my mother, who is now deceased, wanted to testify via Zoom, prejudicing my defense, and that a cooperating witness is no longer available to testify. Due process has been violated in that no meaningful due process has been accorded to Daniel, and that no deposition hearings, no pretrial motion hearings, no evidentiary hearings, no immunity hearings, no preliminary hearings, no due process whatsoever have been afforded to me. The only motions ruled favorably were for the sole benefit of the defense counsel's wish to delay my right to a jury trial with false and misleading statements. The state has no probable cause to prosecute Daniel for assaulting law enforcement officers, and those charges should be resolved by the court in favor of my writ. I demanded speedy trial, and I have not consented to waive that right pursuant to SDCL 15-6-38. B. Demand for speedy jury trial. Defendant was arrested on October 1st, beaten, assaulted, and advised by the courts of my right to a speedy jury trial and acknowledged understanding to which the courts pursuant to SDCL 15-6-48 issued a scheduling order with deadlines to which the state courts and defense counsel in contempt failed to adhere to, violating constitutional speedy trial and due process rights. SDCL 23A-44-5.1, the time allowed for disposition of criminal case. Section 4B, requires consent from the defendant, to which defendant had not granted consent to delay. Counsel failed to prepare. If the defendant is not brought to trial before the running of time for trial, prejudice to the defendant is presumed, and the defendant shall be entitled to dismissal with prejudice, reaffirmed by Title 18, Sections 3161F. Time limit between arraignment and trial shall be 180 days. See scheduling order dated 10/19/2021, Exhibit 1, and motion order for delay filed 1/3/2022, Exhibit 2. Motion for delay filed 3-2/2022, Exhibit 3. Motion for delay filed on 4/27/2022. All motions were considered and granted without my consent or without my knowledge, and trials were reset in every instance 1 week prior to scheduled trial, several days after the trial reset deadline. I move to exercise court's power to dismiss with prejudice CRI 21-6928 and CRI 21-7147 due to the state's, the court's, and lawyers' constitutional violations. Pursuant to Chapter 16-18 Rules of Professional Conduct, the duties of the lawyer and special responsibilities of prosecutors, any waiver of rights must be obtained in writing. Lawyers were not authorized ever to waive any speedy trial rights, nor did they obtain a written waiver or verbal. Any and all delays were considered and granted without my consent and with deliberate indifference to constitutional rights, prejudicial to myself. Pertaining to the delay filed on 4/27/2022, DeCastro deceives the court by signing electronically a statement. He falsely represents to the court that he had spoken with me about that particular motion and had obtained my consent. DeCastro deceived the court. I, Daniel Gomez, had no communication with DeCastro in regards to delaying trial. While I was out on a furlough for either my mother's passing or the funeral. I got out 2 little furloughs. Anyways, and they said I was a flight risk and this and that, but I came back from the furlough twice to the county jail. I returned to custody to face these charges and defend myself, right? And they just delayed trial for 11 more months after I came back. Anyways, any and all communications prior to furlough are on the jail email servers for inmates. No such discussion or notice was given to me. See Grievance Exhibit Number 2, Attachment 1 of 1, and corresponding motion in order for delay. In closing, pro se petitioner asserts and alleges supported by legitimate internally generated documentation in the exhibits herein and the U.S. Constitution, State of South Dakota State Constitution, and reaffirmed by federal and state laws, my federal constitutional rights, due process rights, speedy trial rights, 180-day rule have been violated. These cases here, 1, 2, and 3, are speedy trial cases. Certificate of service. I sent all this to the Supreme Court. Again, you can handwrite this stuff from county jail. I did all this from county jail. These ones that are handwritten like this. So with all these petitions, you see the federal courts denying me my right to a 7th Amendment civil jury trial. Oh, it's dismissed on this summary judgment. Summary judgment is an unconstitutional policy adopted by the United States courts. Summary judgment does not grant you, it violates the 7th Amendment principles of your right to a civil jury trial. Summary judgment, the failure to state a claim, and all them other reasons that they dismiss your case without even serving the other party. Those practices and policies are the rules that are violating people's constitutional right. They contribute to the violations by denying you the relief. It also violates your First Amendment right to petition. They're going to say, oh, well, you got your right to petition. Nobody stopped you from making the petition. No, but you stopped the petition from going forward and getting a 7th Amendment jury trial. You're doing who agreed to have a bench trial. And now these judges are practicing law from the bench, defending people that haven't even been served with these complaints. They're not even allowing them to see the complaint. They're shielding them. They're obstructing. What do they call it? That's called harboring. They're harboring these people from justice. Let's go to the habeas corpus petition. Let's skip this one. We'll go back in time, since they brought up my second-degree escape charge and the habitual offender statute on 2 cases. Let's see, 21. Page 21. This is my Appendix E that went to the Supreme Court here in the United States. Exhibits of fabricated warrants, docket history. Here's the fabricated warrant. So my lawyer told me that there was a warrant for failure to appear. The police officer told me it was a warrant for failure to appear. See Melissa Larson? She's a clerk of court. She signed it there as a magistrate judge. See this page here? This is the circuit court header. This is a list of the judges. 1, 2, 3. This is the list of magistrate judges. There's only 2 magistrate judges. This document was filed September 16th, 2009, after that. So Melissa Larson was still employed there. She was not a magistrate judge. She impersonated a judicial officer. See, this was her true position up here. A clerk of court. Melissa Larson. See the signature? Same signature. This Exhibit C portion was stamped and filed on March 1st, 2010 when I did the habeas corpus. What they did was they dropped the charges for the unlawful arrest and created a whole different charge of this. So earlier I was talking about what a failure to appear is, just a misdemeanor, right? Failure to appear is a misdemeanor. They like to convert misdemeanors in the state of South Dakota and charge you as felonies so that they can bring up other misdemeanors from other states and charge them and say that those are felonies to give you life in prison. This is the orders. Bond specifying methods and conditions of release. I paid cash only. Okay, I signed it. If I fail to appear before the court, is required an additional charge of failure to appear may be instituted against me, not second-degree escape. Stephen Jensen's signature again. June 23rd, 2008. Melissa Larson, Union County Clerk of Courts. She's not a magistrate judge. She had no authority to issue this warrant. She fabricated the warrant. She impersonated a judge. So on June 7th, she fabricates that warrant and says it existed on February 2nd of 2006, years before this. See? Melissa Larson, Union County Clerk of Court. So she was a clerk of court in June 23rd. That warrant, I got arrested June 7th of 2008. So 2 weeks before, it took me 2 weeks to bond out. Did she get demoted within that time? No. She was never promoted to a judge. Released, bonded out. Complaint. This ain't even an indictment. They charged me with second-degree escape. It says over there I could be charged with a misdemeanor, a failure to appear. Here, accusing me on this paper of failing to appear. But failing to appear and charging me with escape. I'm gonna cut out, guys. Thanks for the taps. Thanks for the shares. Any questions? Hey, Farrell. So 90 minutes. Hey, Farrah, thanks for the gift. Hope Mustafa and his family try to utilize this stuff. I mean, it's hard to get information from out here to in there. And if you're in there, it's hard to get information from in there to out here. Thanks for the taps. Thanks for joining me, Mr. Wolf.